What about the right to information? Does it have any link with the right to freedom of speech and expression? We'll find this answer again from an authoritative judgment from the Supreme Court, and this is what the court has declared. Freedom of speech and expression includes right to acquire information and to disseminate it. So the right to acquire information is included in the freedom of speech and expression. Freedom of speech and expression is necessary for self-expression, which is an important means of free conscience and self-fulfillment. It enables people to contribute to debates on social and moral issues. Thus, the right to acquire information and to disseminate it, to spread it, is also a fundamental right for the citizens of India, and this flows from the provisions of Article 19, Clause 1, Subclause A. The right to acquire information and the right to disseminate this information, to spread this information, flows from the right to freedom of speech and expression. This has been so declared by the Supreme Court in 1995 in the case of Secretary, Ministry of Information and Broadcasting versus Cricket Association of Bengal. It has been declared by the Supreme Court that freedom of speech and expression is a basic human right. Let's see what the court has said on this aspect. The Supreme Court has declared that freedom of speech is the bulwark of a democratic government. This freedom is essential for proper functioning of the democratic process. This freedom is regarded as the first condition of liberty. Freedom of speech plays a crucial role in the formation of public opinion on social, political, and economic matters. It has been described as a basic human right or a natural right. This was stated by the Supreme Court in Ramlila Maidan incident in Ray in 2012. Now, we have seen earlier that reasonable restrictions can be imposed on the exercise of all of these rights on different grounds by the concerned legislature. What is meant by reasonable restrictions? Which restrictions are reasonable? It is for the courts to decide in each case of restriction whether the restriction concerned is a reasonable restriction or not. So what principle should the courts follow in deciding whether a given restriction is reasonable or otherwise? The phrase reasonable restriction connotes, in the words of the Supreme Court, the limitation imposed on a person in enjoyment of the right. Restriction will impose a limitation. The court says that this limitation which is imposed on a person in enjoyment of his right should not be arbitrary. This is the first thing. The limitation or the restriction should not be arbitrary. It should not be of an excessive nature. It should not be beyond what is required in the interests of the public. So the interest of the public is of paramount importance. The restriction should have a bearing on the interest of the public. Restrictions can be imposed only in the interest of the public. And of course, there are other grounds on the basis of which restrictions can be imposed. All those grounds have to be kept in mind. This statement was made by the Supreme Court in the context of the interest of where the restriction was could be imposed only in the interest of the public. On reasonableness of restrictions, we have an important authoritative judgment from the Supreme Court in Papnasam Labor Union versus Madura Courts Limited. This is what the Supreme Court says as to how to determine whether a restriction is reasonable or not. The court says, in judging reasonableness of the restrictions, the court has to bear in mind the directive principles of state policy. The directive principles of state policy is one of the parameters which the court can keep in mind when it is asked upon to decide whether a given restriction is reasonable or not. A restriction which has the effect of promoting a directive principle can be presumed to be a reasonable restriction in public interest. Whenever the ground on which the restriction can be imposed is the ground of public interest, then a restriction which has the effect of promoting a directive principle can be presumed to be a reasonable restriction. So this is one of the parameters in deciding whether a given restriction is reasonable or not. This is a workable solution to this vexed issue. Now next we will consider constitutional validity of certain laws which restrict the freedom of speech and expression. We have already seen that by virtue of Article 19 Clause 2, restrictions can be imposed on the freedom of speech and expression. The only requirement is that these restrictions should be reasonable, and these can be imposed only by the legislature, and further these restrictions can be imposed only on the 9 grounds which are enumerated in 19.2. Legislature has made certain laws which have the effect of restricting this freedom. These laws will be constitutionally valid only if the restrictions imposed by these laws are reasonable, and also the restrictions should be only on the grounds which are enumerated in 19.2. So the first law which we will consider is the law of sedition. The law of sedition is contained in section 124A of the Indian Penal Code, and this restriction or this law was considered by the Supreme Court in 1962 in Kedarnath Singh versus State of Bihar. Law was laid down in this case, which is still in force, and now we will see what that law was. But before we go to the law of sedition, we will first see what restrictions are imposed by this section 124A of the IPC. This section says that whoever by words spoken or written or by signs etc. brings into hatred or contempt the government established by law in India, or excites disaffection towards the government established by law in India, shall be punished with, and then the punishment is given. It may be imprisonment for life, it may be imprisonment up to 3 years, or it may be simply fine. But an offense will be made, an offense will be committed if the government established by law in India is brought into hatred or contempt, or if towards the government established by law in India disaffection is excited. Since words spoken or written are included here, this is clearly a restriction on the right to freedom of speech and expression. The question is whether this restriction imposed by section 124A IPC is reasonable and within the bounds of the restrictions permitted by Article 19 Clause 2. The Supreme Court considered this provision and then gave this judgment. Though the section imposes restrictions on the fundamental freedom of speech and expression, the restrictions are in the interest of public order. And you will recall that public order is one of the 9 grounds which are listed in Article 19, Clause 2. The court says that the restrictions imposed by 124A IPC are in the interest of public order and therefore are within the ambit of permissible legislative interference with the fundamental right. You will recall that interference can be made only by the legislature. The court declares that this interference made by the legislature through this law by putting restrictions is permissible because the restrictions are in the interest of public order. A citizen has a right to say or write whatever he likes about the government or its measures by way of criticism or comment, so long as he does not incite people to violence against the government. This is important. He can say anything about the government, against the government, so long as he does not incite people to violence or with the intention of creating public disorder. So, if the intention is not to create public disorder and if the criticism or comment does not incite people to violence, then this is not a violation of section 124A. Such a criticism, such a comment is permissible. This is within the right to freedom of speech and expression. And the court says that if we construe the provisions of 124A in this way, then this section strikes the correct balance between individual fundamental rights and the interest of public order. Next, we come to the law of defamation. The law of defamation is contained in sections 499 and 500 of the Indian Penal Code. The question is this: does the offence of defamation, as contained in sections 499 and 500 of the IPC, conflict with the fundamental right to freedom of speech and expression? This question was authoritatively answered by the Supreme Court in 2016 in Subramaniam Swamy versus Union of India. This is what the court has to say in this regard. Before that, we will have a quick look at section 499 and also at section 500. Section 499 defines the offence of defamation. It says, whoever by words spoken or intended to be read, or by signs or by visible presentations, makes or publishes any imputation concerning any person, intending to harm the reputation of such person, is said to defame that person except in cases hereinafter accepted. So, subject to certain exceptions, whoever makes or publishes any imputation intending to harm the reputation of such person. Intention is to harm the reputation. Whether it actually harms the reputation or not, that is separate issue. If the intention is to harm the reputation, then section 499 becomes applicable, and if it becomes applicable, then by virtue of section 500 it becomes punishable, and the punishment prescribed is simple imprisonment up to 2 years or fine or both. Now, these provisions of IPC fall foul of the right to freedom of speech and expression, and the question before the court was whether the restrictions imposed by these two sections are within the permissible limits of Article 19, Clause 2. The court says, in a sense, the offence of defamation is the harm caused to the reputation of a person. This is what is meant by defamation. It causes harm to the reputation of a person. The court says reputation is an inherent component of Article 21. This is a far-reaching declaration made by the court. Reputation is an inherent component of Article 21. And after this declaration, the court says that since it is an inherent component of Article 21, we do not think it should be allowed to be sullied or spoiled solely because another individual can have his freedom. It is not a restriction that has an inevitable consequence which impairs circulation of thoughts and ideas. Therefore, a balance between the two rights needs to be struck. What are the two rights? The right to reputation, which flows from Article 21, and the right to freedom of speech and expression, which is granted by Article 19, Clause 1, Subclause A. Therefore, a balance between the two rights needs to be struck. Reputation of one cannot be allowed to be crucified at the altar of the other's right of free speech. The legislature, in its wisdom, has not thought it appropriate to abolish criminality of defamation in the upturning social climate. Therefore, in the ultimate conclusion, the court says, we come to hold that applying the doctrine of balancing of fundamental rights, here two fundamental rights are in conflict with each other. Applying the doctrine of balancing of fundamental rights, existence of defamation as a criminal offence is not beyond the boundary of Article 19(2) of the Constitution, especially when the word defamation has been used in the Constitution. You will recall that there is one ground, defamation, in 19(2). Of the 9 grounds which are mentioned there, defamation is one of the grounds. And therefore, if restrictions are imposed by the legislature on the ground of defamation, which restrictions are reasonable, then such restrictions are permissible within Article 19(2). And the court then concludes by saying that one cannot be unmindful that the right to freedom of speech and expression is a highly valued and cherished right, but the Constitution conceives of reasonable restrictions. In that context, criminal defamation, which is in existence in the form of sections 499 and 500 IPC, is not a restriction on free speech that can be characterized as disproportionate. So the court declares the restriction as proportionate, which means the restriction is reasonable. The restriction imposed by sections 499 and 500 on the right to freedom of speech and expression is a reasonable restriction. It is a proportionate restriction and therefore it is permissible.